Was it unlawful, though? That's some of the language that was used in that response on behalf of Rozzi and Baldwin, saying that Gull had an absolute duty to refrain from severing the attorney-client relationship there. I mean, this is something the Supreme Court is going to be ruling on and making a decision on in the coming days, weeks, right now.
Yeah, I mean, that's it. If they get to the merits, which and that's when I'm kind of, creating that differentiation
Mhm.
between the procedural side and the merits. That's the merits argument. Um, which frankly, I hope they get to because they need to get to it. There's been a lot of back and forth in that case between the attorneys for Gull and the attorneys for Allen, wherein they're both kind of criticizing one another for not using cases from Indiana
Mhm.
in terms of citing cases, because the way that you argue appellate cases is you cite precedent
Yeah.
typically, and there's two types of precedent. There's persuasive, which is cases that are not from the jurisdiction that you're arguing in, whether it be another court, another state's court, but that it argues the principle that you're trying to put forth to the court, and you'll use it persuasively. And then there's binding precedent, and binding precedent is where your best case scenario is that you have a case from that circuit wherever it may be. That's going to be the most powerful binding precedent on a court, because it's that very court that made that ruling. So in this particular situation, there's barely any case law on it because it
Mhm.
just doesn't happen. So, both sides have been, like I said, they've both been very critical of the other side for not citing binding precedent, and they've been both using persuasive. And there's this one case, Jones, which the judge used, which is an Indiana case, but it's distinguishable in the sense that in that particular case, the lawyers, because the lawyers were removed by the judge, and ultimately the problem for the judge in terms of using that as her binding precedent is that the lawyers were asking to withdraw from the case, which is obviously distinguishable from this case because
Sure.
they weren't really,
Ask no.
I mean, yeah, she's kind of laying on that hope that, okay, well, you know, technically Baldwin
Mhm.
requested to withdraw orally, even though,
Yeah.
clearly when you read the transcripts, he was
Yeah, that's not
forced into
really
doing it.
how that
Right.
that played out. I mean, the only 2 other situations, and this was cited in there, which, the court can remove an attorney, would be if, the attorney isn't a member of the state bar, which obviously they are,
Right.
or there's a conflict of interest. Is there a conflict of interest anywhere in this? Does that conflict of interest come in, to where, they had somebody that got in there, took those photos, they spent 17 days, they said, flat out investigating the leak instead of preparing for the murder trial. Is that a conflict of interest, or is that just what Judge Gull was kind of pointing out, saying, look, this is an adequate representation for you. They're trying to get their ducks in a row over here after this all went down. This isn't fair to you. But then again, Baldwin and Rozzi both say, look, this really did not affect the quality of the representation that we're giving him right now. But it's their words. But at the same time, they also did say they took 17 days working on that. So
Yeah, and as far as goals concerned, I mean, they didn't really even make a conflict
no.
argument, because there isn't one. Had the leak gotten to the point where potentially maybe one or both the attorneys had to testify in court, maybe that creates a conflict. There's a lot of different ways that conflicts arise
Mhm.
between either attorneys and or judges with respect to movements or litigants in cases. And none of those, in my estimation, are here. None of those appear to be the case, especially anything that would rise to the level of removing Allen's counsel of choice.
Mhm.
I think we say it every week. I mean, you have to try to understand that this case, as it's currently situated, while the overarching theme is to get justice for the girls, Abby and Libby, the reality of the situation is that in this part of the process, it's the defendant's rights that we're concerned with. It's the defendant getting a fair trial, which is all that matters at this point. That is what is key.
Yeah.
And and we've talked about it multiple times as well. I mean, ultimately for the girls to get justice, we need them to have this guy get a fair trial,
Mhm.
because otherwise the fact of the matter is this thing's going to get kicked back. And frankly, my opinion on it is that removal, that once Baldwin and Rosie filed their pro bono appearances, they did become his counsel of choice. They were no longer appointed attorneys. And I think that's an automatic remand. I
Yeah.
think that particular situation would theoretically end up with this being a practice trial. Like if these two guys stay on, Scremin and Labredo, and they go through the case and he's convicted, I think it's going to get kicked
Yeah.
back because they removed his attorneys, and then you're doing it all over again,
Yeah.
which is not what the families of the girls want at
Yeah.
all. I mean, certainly, especially if they have more evidence, if they have more evidence against Allen that none of us know about, and there's people out there that think that there's sufficient evidence against Allen based on what they've read in that PCA. I am in complete disagreement with that.
Mhm.
I mean, no one's going to change my mind on it. And I'm coming from a place of experience
Yeah.
speaking on it. I've tried cases, a lot of them, for a long time,
Mhm.
and in my estimation, not going on gut feelings, but going on what's going to be required to prove this case beyond a reasonable doubt. Um, it's lacking, in my
Sure.
opinion.
Yeah.
Now, does that mean that a jury couldn't come back with a guilty verdict? Absolutely not. They absolutely could.
Yeah.
Especially when you have cases involving harm that's come to two young girls that resulted in them losing their lives. Juries want somebody to pay for that, which makes it a terrifying proposition for the defendant and the defense attorneys handling that case, especially if they believe, which I believe that both Baldwin and Rosie completely and 100% believe that their client's innocent of this.
Sure.
And that's a scary proposition, knowing that that's a possibility, because there's one absolute truth about the law. Well, there's a lot of them, but one of them in particular is that you never know what a jury is going to do,
Sure.
ever. So,
And
because you'll get jurors
mhm.
that are of the same mindset of the folks that think that this PCA is sufficient, that the evidence out there, that the fact that, Allen put himself there at the scene and that they found this unspent casing, that those are, he's the guy, I
Sure.
mean, that's like, which is, like I said, from a defense attorney side of it, is terrifying.
Yeah. Hey, it's Tony Brueski. If you want more of our interview with our guests, be sure to check out our podcast, Hidden Killers with Tony Brueski. Just search that wherever you download podcasts and press subscribe. Also, you can check out our YouTube channel for the full video version of the interviews as well, under the same name, Hidden Killers with Tony Brueski. Check it out, subscribe, binge, and enjoy. Thanks for watching.